Your Honor.
Thanks. People against John Lawrence Hodgson III, 25W7156660FY. Are those defendants here yet with the interpreter? If they're not,
they have not checked in with me, Your Honor.
I want you to tell the prosecutor to bring in the files. I'm going to issue a warrant.
Okay.
Second one's not till.
What's that?
The second one is not set till 9:30.
Okay. Well, at least as to the one. Your appearance?
Good morning, Your Honor. Jeff Osmond on behalf of John Hodgson.
Your name, sir?
John Lawrence Hodgson.
Detective Lieutenant David Tiller, Whittier.
So we have, I believe I did the signing on record on this. I don't remember all the specifics. But it was capturing or distributing an image of an unclothed person at 19940 West Road in Woodhaven, and using or installing a device at that location, eavesdropping, and then we also have assault resistant obstructing officer. So we have a 5-year and then a two-year felonies respectively. Does he stand mute? Wait, formal reading?
Yes, sir.
I'm going to advise you of your rights, Mr. Hodgson. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You have the right to be represented by your lawyer not only today, but at all subsequent court proceedings. Also, if you ever choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary exam, if it goes that far as to each one of these counts, the people have to show that the crimes were committed and that you were the one who probably committed the crimes. If they prove that, they'll be bound over for further proceedings to the circuit court. If they fail to prove that, this case would be, as to any one count that they can't prove that as to, that would be dismissed. Do you understand that?
Yes, sir.
Probable cause conference is going to be August 19th at 9:30. That will be in front of Judge Hodgson. August 19th, 9:30. Preliminary exam, August 26th at 11 a.m. in front of Judge Hodgson. I'm going to listen to bond. Could you quickly refresh my memory? What is, Detective Toller, what is 19940 West?
That is Panera Bread, Your Honor.
Okay. Remind me just real quickly what happened here, allegedly.
It's alleged that a customer had observed this subject right here before us walk into the women's bathroom. She recognized the subject from going to high school with them, knew that he had previously possibly been charged with a crime of the same type of incident we're talking here. She went into the bathroom directly after. That's when she located a pen that turned out to be a camera with an SD card in it. She pointed out the subject to officers. He was located, and that's when he took off running and resisted the apprehension, allegedly.
Was there a prior conviction for a similar?
I didn't handle the case, Your Honor, so I don't know firsthand.
All right, what would you like to say?
Judge, when this incident occurred, we've been monitoring it. When the warrant came out, we made immediate arrangements to get him arraigned before the court. He is employed by GM, builds transmissions for them in Toledo. He is a resident of, is it Taylor? Trenton, Michigan. To the best of my knowledge, never failed to appear for court. He's been cooperative with me. And as I indicated, once we found out the warrant was issued, made immediate arrangements to get him arraigned on, and he walked in here today. I'd be asking the court for a PR bond with whatever conditions the court appropriate, but with permission as well to at least travel to Ohio to the GM plant for one. And just so that everybody knows, after my conversation with him, I am going to be submitting for a forensic review. So I don't know if I should send that to Judge Essen, because that's where the next court date will be.
Well, I think you could probably appear by Zoom.
Okay.
And request the forensic then. Should be probably done with you speaking to the prosecutor first, and then if they don't agree, you can argue it. They usually do. Do you have anything that you want are you asking for any kind of cash bond?
No, Your Honor.
And what kind of conditions are you asking for?
Your Honor, I would just ask that, the subject be, asked to stay away from Panera Bread. Any potential, witnesses in this case? But other than that, nothing else.
$10,000 personal bond. You cannot leave the state without the consent of the court. You can leave the state for employment purposes without consent. You cannot violate a law. You must appear in court as directed. The PCC again will be August 19th at 9:30. No contact with Kylie Magyar. You cannot write, phone, see, text, email, or communicate with her or have anybody else do any of those things for you on your behalf. No contact with prosecution witnesses except through your lawyer. You're not to enter or go near 19940 West Road in Trenton. Wait a minute, or that's Woodhaven rather. Woodhaven or any other Panera Bread store. You're not to distribute, and then I got to be careful the way I'm saying this, not to distribute any captured images of this or any other business or any other businesses, I should say, private areas, which would include bathrooms, okay? I'm not saying he has them, I'm not saying he doesn't have them, but he's not going to distribute them, okay? Anything else?
No, sir, thank you.
All right, so do you have anything else?
No, Your Honor.
And he has been printed, right?
I believe so.
He is arrested.
Yes.
Let me just double check here. Yes, he was printed. Okay, and I got the bond sheet filled out. You can go down the hall and you're all set. Good luck. Thank you.
Thank you, Your Honor.
24W834431. Wait 1 second, sir. You can unmute. Is anybody from Walmart here?
Yeah, but,
Pardon?
no. Oh, thank you.
He's an employee of Walmart, just so happily he has nothing to do with
Okay. Okay, no problem. Mr. Crawford, come on up, state your name. Come on up. Your name again, Mr. Shaw?
Jerry Dwayne Shaw.
Good morning, Your Honor. Michael Crawford, representing Mr. Shaw.
He pled guilty, or no contest, I should say, due to a lack of recollection on July 9. This happened in June of 24. There's restitution in the amount of $960 that's going to be ordered to be sent to Walmart. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have had the opportunity to review the report with my client, Your Honor. But there is a material change here. My client indicates to me that he'd like to withdraw his plea.
Withdraw his plea. He's going to have to file a motion. You're going to have to file a motion, sir, to withdraw your plea. You already tendered your plea back on July the 9th. I'm not sure why you would want to withdraw your plea, but he's going to have to file a written motion with notice served on the prosecutor. How long is he in the Monroe County Jail?
Your Honor, he's been in jail now for 6 months, Your Honor.
Yeah, okay. Well, he deserved it. I can tell by looking at this record. I mean, he's a thief. And I don't, so you can file a motion. I gave him a personal bond. He's not getting any credit for any of this time served. And you can file your motion if you want to. I don't know what the basis is. Is there a basis? Did I do something wrong with acceptance of the plea, which I would be shocked to learn? If I did, I did.
The basis for it isn't particularly clear at this point, Your Honor, except for the fact my client now recollects that he doesn't believe he committed the activity.
He told me he had a lack of, you guys, whoever was representing him, I
Yes.
think, he said lack of recollection. So suddenly he's seen God and he's got no recollection now as to what happened on June 24th since July 9th of 25.
Well, Your Honor, my client,
I don't, listen, I don't need to hear this. He can file his motion. Feel free. I'll just adjourn the sentence. You can file a motion. We'll give him a new date. He's not in custody on this. And, did they recommend jail here?
they didn't, Your Honor, they recommended probation, and my client does not want probation, he's asking for time served.
Oh, you want to commit 40 crimes and then have them all run the same time, huh? I love that.
Well, Your Honor, my client is-
Hang on, I'm not done. I just love that. I love that.
Well, Your Honor, my client has attempted to do a plea by mail since November 24th. He sent the documentation to me on the 24th, November 24th, January 25, and as recently as June. He's trying to resolve this matter. And that's why he thinks time served would be appropriate.
Well, he can think what he wants. I mean, if he wants to be a lawyer, he can run for judge too. I don't know what to tell you. I mean, really. What did I do here? I got to see this because I respond to these. I do not fail to respond to plea by mails. I do see one here.
Judge, I do have notes in here if you,
Yeah, I'd love for you to enlighten me.
it looks like we did receive a plea by mail. I contacted the jail. They had transferred him to Oakdale Recovery. Then I contacted Oakdale Recovery with no response and mailed a notice to Oakdale, no response. And then we got another one saying he was back at Monroe. So that's when I did the writ to Monroe.
That's kind of the point. He did everything he could to try to plead to this, and he just spent an additional time in jail.
He's not spending any time in jail on this. Has he spent a day in jail on this? I gave him a personal bond from the get-go. I gave him a personal bond of $2,500.
So what I'm saying is he somehow, it sounds like he's got lost in the administration of all of this thing. He would have pled months ago, and if you would have sentenced him to jail time at that time, he would have spent his 40 days.
That's not our fault.
Well, he did everything he could. He sent it to where he needed to. There's acknowledgement of receipt.
Listen. I probably would have denied it. He can file his motion. He can file his motion if he wants to. How long's he supposed to be in there?
Mr. Sharp, do you know how much time you have left?
October 9th.
He can file his motion. He's getting a personal bond. Maybe we'll delay this. I don't know what to do. I mean, I don't know what I'm supposed to do. We tried to track the gentleman down. I don't ignore these. I'll tell you though, how old are you? You're 47?
Be 48 here in 2 weeks.
Your record, wow. You spent your whole life being a thief, it looks like.
I'm not a thief, Your Honor.
Oh, okay.
Told you that before.
You got a robbery armed from 97, another one from 14, larceny in 22, organized retail crime felony 23, retail fraud
I had a
23,
bad step.
felony financial transaction device 24, identity theft 24. I don't know what, if that doesn't qualify somebody as being a thief, I don't know what would. I'll let you file your motion. I have no problem with you filing your motion. We're going to adjourn the sentence. And he can file his motion, but I don't know what the basis is. You have to have a basis, and I don't see what the basis is.
Your Honor.
He didn't, hang on, I'm not talking to you right now. He didn't show up when he was supposed to be here in August of 24. If he'd have shown up then, we would have adjudicated the case then, and then he would be done. He didn't show up. We sent show causes out, you know. So I'll be glad to let you file a motion, but don't hold your breath that I'm going to grant it. Adjourned sentence, Lisa, we'll give him 4 weeks. That'll give him plenty of time to file his motion.
September
Unless you-
3rd. Oh, sorry.
Unless you can think you can file it before then. You want to set it September 3rd? Is that what you said?
Yeah, September 3rd at 8:30.
So I'll just make a note. Defendant wishes to file a motion to withdraw a plea. Motion to be filed by let's see, we'll make it August the 22nd, okay?
You know, that's gonna be tough. I'm gonna be out of town that week.
Well, I'm giving you 16 days. I mean, how many more, what do you want? The 25th, 26th? I mean, I'm giving you 2.5 weeks. Today's the 6th.
I appreciate that, Your Honor. I would appreciate the 26th. Just in case.
Okay, that's not a problem. I'll give you that. Just make sure you get it to the prosecutor that day so they can respond. Motion to be filed by August 26th. We'll be here September 3rd. At what time? 8:30, right, Lisa?
Yes, 8:30.
I mean, I'm gonna listen to him. He's gonna pay his restitution though. If he's convicted of this, he doesn't just get to say, give me time served, I get the money for free now.
And I didn't ask for that. I asked for restitution. My whole thing was, I have no problem paying. I'm a plumber. I had that paid within months of getting out.
Listen, so far, just from what I read here, nobody's gonna accuse you of being a choir boy, okay?
No, sir.
So
I'm not gonna
don't
accuse myself
act
of being a
like
choir boy.
your word should be taken as a given, okay?
Yes, sir.
We see these things every single day. They're not hard to spot. I could spot them in 96. This is crazy. Don't sit there and tell me, oh, I can pay this and I can pay that. If you got so much money and you're willing to work so hard, you wouldn't be out thieving everybody. Now,
If I
let's
wasn't
just,
getting high,
I'm not done. I'm not gonna deal with this. You wanna withdraw the plea? I'm gonna let you withdraw your plea on a showing that complies with the court rule. Your lawyer's getting plenty of time to file a motion. I'm giving him plenty of time. This is not prejudicing anything about you. You've got a personal bond, and that's the way it works. So I'll see you here in September. I wish you well. Good luck. Thank you.
Thank you, Your Honor.
Can I talk to somebody again on Zoom?
Yeah, they'll talk to him on Zoom, absolutely. But I gotta, don't let him go, Lisa. Mr. Crawford wants to speak to him.
Okay, counsel, on Deanne matter, what I'm gonna do is I'm just gonna adjourn this out to September 3rd.
May I make a request now?
You're going to anyway, so yes, go ahead.
Could it be past that date? So I applied to visit him in Moraga.
Got it. You've gotta get in. Will the 17th, you think, give you enough time? Probably not.
It might not, to be very frank, Your Honor. I'm not optimistic that would be enough time. It might be.
Why, they don't have you on the list?
No, I applied.
Cause you're like suspicious, aren't you?
Maybe, if that's the thing.
That's why.
I was all ready to go in person to the
First.
at this point, but now he's not there, so.
I said vacation.
October 1st,
That'd be great. Thank you so much. Your Honor.
2025, 9 a.m.
Thank you.
Miss Perrine, nice of you to show up. I mean, good morning.
Good morning.
How are you doing?
I'm doing well, Judge. Thank you for asking. How are you?
I'm doing great. He said, what's his name to get breakfast? But watch, he's not gonna bring enough for all of us.
I was gonna
What kind
ask
of
him for a
breakfast?
Happy Meal.
Huh?
McDonald's. He's going to McDonald's.
He's going to McDonald's. We don't know which McDonald's he's going to.
Mr. Bird.
That's a good McDonald's over
It
there.
is.
Mm-hmm.
As opposed to the bad McDonald's?
Okay, I live by a horrible
Me
McDonald's.
too.
Same here.
Okay, let's broadcast that to the world.
It's,
All
I
right.
will. It's like, it takes forever. They never have anything you want.
This one's.
You seem a little bitter,
It's
Perrine.
so close to my house. So easy to go get a Happy Meal for my child when he's.
Oh, now you're bringing the kids in.
But I can't.
All right.
It's horrible. I avoid that McDonald's.
Okay. All right, I'm gonna stand in recess. You need to calm down in the interim.
Okay.
All right, and I'll come back and we'll start the next block. Court stands in recess.
All right.
Court calls the case of the People versus Alexis Brown.
Christina Berry.
Good morning, Assistant Public Defender Lauren Perry on behalf, well, not on behalf of Ms. Brown. You know, we are the attorney of record on this case. When I did meet with Ms. Brown. She informed me she wants to represent herself.
Your name?
Alexis Brown.
All right. Is that correct that you want to represent yourself?
Yes, it is.
So in this matter, Ms. Brown, I do have to inform you that the complaint in this case alleges that on or about June 8th, 2024, location of 3001 Woodland Hills Drive in Pittsfield, Washtenaw County, State of Michigan, that you did commit the offense of assault and or assault and battery against a Latasha Browning. Do you understand what you're charged with?
Yes, I do.
That is a misdemeanor, punishable by 93 days in jail, $500 fine plus court costs. Do you understand the maximum penalties?
Yes, I do.
There are certain things that are fraught in self-representation, in terms of understanding the Michigan court rules and in terms of the court procedure. You would need to understand that if you would like to represent yourself, that you would be held to the same standard as any other attorney.
Mm-hmm.
The court will not be assisting you in any fashion whatsoever. You understand that?
Okay, so the time that I served, don't that counts for the 93 days?
I'm sorry?
The time that I served already, don't that counts for the 93 days?
I don't know how much time you,
I served 30 days already.
and if you serve 30 days, it may count. I'm trying to look at what your bond is on this case. What do you have a bond?
And then no contact with the victim's loan.
And the monetary amount, 5,000, 10%, then it should count. Yes, ma'am.
And so I have a question. So when I was arrested, I wasn't actually told my rights. So ain't that against the law that you wasn't told your rights when you arrested me? Well, not you, but the officer.
I cannot.
You can't do nothing about it right now?
I
All right, I just want to state that.
I can't answer that.
I just want to state it.
All right.
Okay,
Stated.
it's on record, right?
So
Okay.
what do you want this set for, ma'am?
I mean, Your Honor, we have no offer at this time.
Do you want it set for a trial, ma'am?
Sure, I guess, if I guess.
You want a jury trial or a non-jury trial?
It doesn't really matter.
Well, you've got to make a decision, ma'am.
If it gotta go to trial, then it gotta go to trial.
Okay. Do you want a jury trial or no trial?
It doesn't matter.
You have to make a decision, ma'am.
It could have a jury, fine, that's fine with me.
Jury final settlement conference in this matter will be set for 17th, 2025 at 9 a.m. Jury selection in this matter, October 20th, 2025 at 8:30. Both of those proceedings are in person. Thank you.
So am I free to go? So why am I not free to go? If she just said she ain't got a bond,
Pardon?
why am I not free to go? Why do I gotta serve time when I'm not even?
You have a bond on the case, ma'am.
So if I get my money, I can get out. But she just said it was no bond.
Post bond, you can get out.
So I'd rather post bond. So where do I go from here?
You need to post the bond.
Okay, what's the bond? Cause you just asked her the same thing. Cause she said
5%.
it's $500.
Yes, ma'am.
Okay, so I'd rather post bond. Where do I go from there?
And you can go post bond.
Okay, thank you.
It's your fault, parenting. Your fault. You just like suckered me into that. You got up there and then just said, well, we're the attorney of record, but
Oh, we're starting off the morning with a series of bad decisions already. This is wonderful.
Yeah, I know, but they're all by Kearney. The whole
That's-
McDonald's thing and then this. And...
This,
Okay, let's try this one. Court calls the case People versus Deja McCoy. Is she here? Oh,
Brandon Center, Your Honor. Actually, she was there when I was walking out, Your Honor.
how come you didn't come back? You guys got to switch sides.
Sorry about
How come you didn't come back?
I came back, but you was gone. I figured you
I have
left the
been
bench.
here.
I
Don't
figured,
say
I figured you left the
No.
bench. I
Why
figured
didn't you
left
come
the
back?
bench.
The client was here.
When I was
And the
going
things
out,
he was saying about you, I was defending you. I want you to.
I was
Okay.
saying dismiss.
He was, I think, making. Okay. Reality is, I think you were making your decision because you wanted McDonald's, and you kept saying she wasn't here. That's why you didn't come back down the hallway, isn't that right, Bert?
No, that's. No, I'm talking about when
Yeah.
I was walking outside. We crossed each other's path.
Outside, you weren't going to turn around.
Oh no, I wouldn't have did nothing like
You
that.
had McDonald's on your mind.
I would have got Coney. I had Coney on my mind for real. But I had to stay there. Didn't have time for it. But yes, Your Honor, Brandon Bird on behalf of Deja, Yargi McCoy. Ms. McCoy, can you please state your full name for the record?
Deja Nicole McCoy Yargi.
Thank you, man. All right, what are we doing?
Respectfully, Your Honor, we just asked for adjournment to give me some time to talk about the offer with my client and to go over these videos with her.
Okay. September 3rd. Have enough time, sir?
Actually, I'm started trial on September 2nd, Your Honor, and I'm not sure if it'll be done on the 3rd.
Yeah, like you. September 17th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Have a
You
good
and
day.
Your Honor, have a good day.
Okay. Did you get your food?
I did.
Okay, all right. Call the case People versus Devon Julia Martinez.
Conrad Solar on behalf of Pittsfield Township.
An Assistant Public Defender Natalie Pate with and on behalf of Ms. Martinez. Please state your name for the record.
Seven Julia. Hi.
Thank you, Your Honor. I am respectfully requesting both an adjournment and if the court would consider a possible release to treatment for Ms. Martinez. I can provide Your Honor with an order. It is my understanding she is still being held on her felony matters, but she is hopeful that she can get a release to treatment on those cases as well. So I'm making that request on her behalf, as well as asking for an adjournment.
Excuse me, I'd also like to keep the $500.
I'll adjourn this to September 3rd, 2025, 9 a.m. And any objection from the people about release to treatment?
No, Your Honor.
Then if you submit an order to the court, I will sign that order.
Thank you, Your Honor. And my client is asking for clarification. Is her bond currently $500? However, she would not have to pay that to be released in treatment, correct?
Right.
I would like.
I would release her to PR on a treatment. I would release her on a PR to go to treatment.
But $500 still exists.
But if she doesn't complete treatment, and we've been down that path before, she comes back.
Understood, Your Honor.
Okay,
So
but there is still a bond.
the judge just gave you a PR to be released to
Okay,
treatment.
but does the $500 bond still exist? Is it there still? Is it also? Yes.
If that is what your bond is currently a PR to treatment, but you would be still getting credit for your time in custody.
Okay, can we keep the $500 bond as well?
Well, it'd be a $500 bond until they find treatment, then it will transform into a PR so you can be released to treatment.
Okay, so, but it still is a $500 bond if.
Right now, yes.
Okay, thank you.
Yes,
Thank
but this
you.
will not hold you up from going to treatment.
Okay, thank you. So can I?
Thank you, Your Honor.
Let me step back.
You gotta keep going, Ms. Martinez. Gotta keep moving. Apparently, that's your fault too. Court does call the case. People versus Anthony Miller. It's the stupidest thing in the world. Information. Hey, just
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Miller. Good morning, Ms. Miller. State your name, please.
Anthony Lavelle Miller.
Thank you.
Your Honor, two things regarding the pretrial. I'd asked for an adjournment. Mr. Miller would like to do some additional investigation,
Okay,
and he would like me to address his bond.
okay. Why don't you, how much time will it take you to do can you do that by the 3rd?
I think so, Your
Okay,
Honor.
all right.
Thank you.
So I'll adjourn the pretrial to September 3rd, 2025, 9 a.m.
Regarding his bond, he just saw, Your Honor, on Thursday on a felony. You did modify his bond to a personal bond because the public defender that represented him then provided, Your Honor, with proof of incarceration. That is why he missed his felony PCC. He has $100 bond on this case. We're asking for a personal bond to be released on this one. I have the proof of incarceration as again, that was provided.
Where's he gonna go? If I,
The Line Center.
When his pretrial that he missed on this file was the 18th, he was incarcerated at the Wayne County Jail, according to the sheriff there, on September 17th of last year. So again, he's asking for a personal bond. I did get a good phone number for Mr. Miller. He does have a phone, so if and when he's released.
no, you keep going. I've already made my decision, but go ahead.
Well, we'll
I
communicate.
just like hear you talk. Go ahead.
That's all I have to say.
That's all you have to say? Okay.
That's it.
Bond is reduced to a personal recognizance, $5,000.
Thank you, Your Honor.
Thank
I'll
you.
call
Honor.
Mr. Miller.
Have a great day.
You do the same.
God bless.
Make sure you come back.
Yes, sir.
Court call. Yeah, make friends.
He's happy.
Is he?
Yeah.
It must have been something you did. Court calls the case People versus Tierra Peterson. Then I'm down to, that's my last one.
And on behalf of the people.
Conrad Seller on behalf of Pittsfield Township.
And Assistant Public Defender Natalie Pate for Miss Peterson, who I hope is present via Zoom.
Tierra Peterson? You think she's the Motorola? Tierra Peterson? Court calls the case of the People versus Brian Foley. You don't have to close this out?
And on behalf of the people, Your Honor.
Pardon?
I have this listed as no counsel, I believe Mr. Foley.
He's here.
Yes, gentleman in the back.
Mr. Foley?
Have you not to be like this?
Just take them. Okay. On me, yes, Your Honor. All right. State your name.
Brian Foley.
All right. Mr. Foley, you're not represented by an attorney, right?
Correct.
All right, what are we doing on your case?
I had a unpaid traffic ticket, which I have since paid from out of your courtroom.
Okay, hold on. You're here on a DWLS, a driver's license suspended, and I see what you're saying. So what you're telling me today is that your license is now valid.
Correct, Your Honor.
All right. I can verify that his license is valid.
Then the people move to distance, Your Honor.
He did that all on his own? He didn't want an attorney and he got his case dismissed? Get Mr. Foley out. All right. Yeah, I'm sure you don't have any objection to the dismissal.
I don't, Your Honor.
All right, this case is dismissed.
Yeah, I know not to come before you unprepared.
Is that right? Yeah. All right, Mr. Foley, got it? Okay. Foley, you take care of yourself, sir.
Your Honor.
Court calls case People versus Micah Jones.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Jones. Mr. Jones, please state your name for the record.
Michael Jones.
Hey, what are we doing?
Your Honor, I guess we don't have an agreement on this charge, but Mr. Jones is going to be pleading guilty as charged to the retail fraud third. From my understanding, in my math, is maxed out on this charge. I do have a signed plea form and an advice of rights form as well.
Okay. And do we know if there's any restitution?
I don't believe so. I think everything was recovered.
Okay, well, they looked that up. Can I have them sworn?
You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Lower than spell your hand name.
My name, MICAHJONES.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud to third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes.
You understand you're giving up your right to appeal over.
Yes.
Are you on probation or parole?
Yes.
You are?
On probation.
All right. Were you on probation at the time of this offense?
I believe so.
All right. I do have to advise you, this could be considered a violation of that probation.
Yeah. Judge Washington said something about it.
Pardon?
Judge Washington, she said something about it.
Okay. You understand that if it is considered a violation of that probation, you could be sentenced to the maximum allowable under that other charge. And understanding that, you still wish to plead guilty to this charge?
Yes.
Anybody promise you anything other than what's been stated here today on the record?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Yes.
Because you believe that you are indeed guilty?
Yes.
All right. Let's see. July 2nd, 2024, it's location of 3825 Carpenter Road, that being the Meyer, Pittsfield Township, Washtenaw County, State of Michigan. What did you do on that date that makes you think that you're guilty?
I did retail fraud.
The retail fraud. Okay. You went into Meyer.
One of Myers, I stole a few items.
And you took some items.
Yes.
All right. You tried to walk out without paying for them?
Yes.
All right. Store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No.
And these items that you took were offered for sale by Meyer?
Yes.
All right. Sir, if I do accept your plea, I do have to advise you that between your plea and the time of sentencing, and if you commit misconduct that's defined in the Michigan court rules, you would not be entitled to withdraw your plea. And also you would not be entitled, since there is none, to any sentence recommendation or evaluation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes.
Court will accept the defendant's plea of guilty to this charge. All right. How long has he been in?
We did the math since he was arraigned. Has
April. I have an April arraignment date on this case.
I'm sorry, we did the math together, Mr. Jones and I.
Okay, but I'll trust Mr. Jones' number. I've seen you do math.
No, I know. Well, okay, so since his arraignment, he has 24 days, I believe, but since the date of the offense, he has I think 100 days.
Where are you getting this 20 days? Was he out for a period?
He was in from October 7th, 2024 to December 6th of last year, then back in February 13th, 2025 to April 8th of this year. And then he's been in for 23 days. He was booked on July 15th, 2025.
So how many days do you have for him? I thought you guys did this.
Okay.
I know, we did it yesterday, the night it went down.
No.
Okay, no, I think Parity should have to do the math.
Oh, I have 133 days since the date of the offense here. That was 6 days ago. I'm sorry, I should have had.
You're right. You are absolutely right. I was just gonna wait, see if miracle happens. Sir, is there anything you want to say before I approve sentence?
No, I apologize for what I did. I said I'll never do it.
Pardon?
I promise them not to do that again.
$125 statutory fee, 93 days in jail, credit 93 served. You're all set.
Thank you so much.
Take care. Court calls case People versus Ashley Garcia.
Defender Natalie Pate for Ms. Garcia, who may be present via Zoom.
Garcia? Nah.
Your Honor, I do have a phone number for her that I was able to leave a voicemail at. That being said, I got back and I got a reason for failure to respect the request and adjournment for the record.
Yeah. Might have another phone number if you had access to JAF.
I would speculate maybe. I don't know.
Yeah,
Might have been
no,
the
no,
same one,
but
might have been new.
we don't know anything because of what's happened, right?
That's no
true.
idea.
Yeah, I know. I don't know why they put you in the dark that way. Bench warrant, 5,000, 10%, but I won't have that issue until the 13th.
Thank you, Your Honor.
Court calls case People versus Jacqueline Murray.
Christina Berger, for the people. Your Honor, this is the way that we retrial.
Okay, your name?
Jacqueline Murray.
All right, Miss Murray, you are before the court on a misdemeanor complaint that alleges that on or about March 10th, 2025, at the location of 2451 Twin Lakes Drive in Pittsfield Township, Washtenaw County, State of Michigan, that you did break and enter a vehicle with the intent to steal property valued at $200, but less than $1,000. Do you understand what you're charged with?
I understand what I'm charged with.
Okay, that's a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
I understand.
All right. First question I have for you is, you want to be represented by an attorney?
Yes.
Public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Murray, we would waive any further reading, stand mute. And Your Honor, I would ask for an adjourned pre-trial date as well as a nominal bond. It's my understanding Ms. Murray is being held on other matters. I do not know that, or I was pulling up the next dates, which I do not have.
And in every way, formal reading, standing mute, court will enter not guilty plea. Pre-trial in this. When is, she's being held on other matters?
She is. I do not have her next court date.
Okay.
Tomorrow.
And that's, go ahead.
It's Alexander, Your Honor. On extra, I have, she has hearings on, there's one on the 13th of August.
Next week.
The ones, I think there's some.
Oh, she's here tomorrow on a felony.
Yes.
Okay, let me do it this way. I'll just adjourn her out to September 3rd, 2025 at 9, my next available date. I'll set her bond in this case at the $500 10% bond at this time. I'll order standard conditions, including no assaultive behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. Okay?
Thank you, Your Honor.
Thank you. Yes, hold on. Hold on a second, ma'am. Yes, no contact.
To the Wellside Lake Apartments at 2345 Woodridge Way. That's the location that the offense took place.
What was the address you gave? Because I have Twin Lakes Drive.
You said will pull it up, but I have in my notes on which way she will.
That's what we have on our bond form, your honors, Gulfside Lakes Farm is 2345 Woodbridge. Way.
Oh, okay, I see. So it's Gulfside Lakes. All right.
That's in the apartments.
All right, I will add the conditions, not, you're not to enter Gulfside Lake Apartments.
And one more thing, I'm sorry, Your Honor. For the bond, if I can request a $5,000 security bond, this defendant has numerous outstanding warrants for the year. And multiple of those warrants have a $5,000 bond associated to them. So I'd like to respectfully ask if they could address the bond.
So cash or security bond? Cash or security, is that what you
I'm in
want?
jail, so I'm not going nowhere.
I got this one, don't worry.
Thank you.
I got it. I'm gonna decline to do that. She'll be held on this, as I've said.
Thank you.
All right, you're welcome. But I appreciate your help and trying to help me out. Yeah, okay.
Thank you.
All right. Case People versus Melissa Hatfield.
And on behalf of the people.
The arraignment. All right. Come on up, man. What's your name?
Melissa Hatfield.
All right, Ms. Hatfield, you are before the court on a misdemeanor complaint that alleges that on or about April 22nd, 2025, at the location 4860 Washtenaw Avenue in Pittsfield Township, Washtenaw County, State of Michigan, that you did commit an assault and battery upon a Carolyn Latham. Do you understand what you're charged with?
I guess so, yes.
Well, you guess so, or do you know what you're charged with?
I do understand what I am.
Okay. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
First question I have for you, ma'am, is do you wish to be represented by an attorney?
I honestly don't know. Today is my first knowledge of this case even being valid. I was never notified prior to the court to even be here, other than there is now a small claims trying to go against the business where I work. And then
There's what now?
There's, I guess, a small claims case trying to go against the business where I work.
By who?
The same person.
Okay.
And that was when I was made aware that I was also being charged. I was never no prior knowledge at all.
Okay.
So I'm okay with representing myself, yes.
You are?
I am not guilty, sir. So
Well,
yeah.
that's fine. I mean, I don't think getting an attorney means you're guilty or not guilty. It doesn't mean anything. It's just, what do you want to then do on this case?
I would plead not guilty.
Okay, I'll enter your not guilty plea, but then what do you want to do next on this case?
I would assume that charges should be dropped.
Okay, that doesn't just happen by magic.
Okay. Tell me what I need to do, please.
I can't do that. I can't tell you what you need to do.
Okay.
So I'm going to ask the question again. Would you like an attorney to assist you through this process?
Yes.
Good answer. This is a public defender case.
Yeah, like I said, I was never made any prior knowledge.
I just don't want you saying anything about it, okay?
Assistant Public Defender Natalie Pate, and on behalf of Ms. Hatfield, we would waive any further reading. My client stands mute, and we would ask that a not guilty plea be entered. We would ask for an adjourned pretrial date as well as a PR bond, please, Your Honor.
All right. What I will do is I'll adjourn this matter to September 17th, 2025, 9 a.m. I've entered her not guilty plea. I will set her bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assault to behavior or possession of any weapons. I would indicate at this time there's to be no alcohol, recreational marijuana, or any illegal drug use. I'm going to order no contact with Carolyn Latham. You understand that, ma'am?
Yes, sir, Your Honor.
All right. And the 4860 Washtenaw, what is that?
I believe it's called dental house or the dentist's office. So
We were scrapping at a dental office? No, I'm kidding, allegedly. Okay, so, pardon?
I'm not sure if you'd ask for a negotiation, I believe that's where.
You work there,
I work there currently.
okay, but Miss Latham does not work there? Or, okay, gotcha. So I'm not gonna order that, I'm just gonna indicate you're not to have any contact with her, okay?
Your Honor, may I ask, how do you spell the last name? I apologize.
Oh, Latham,
Yes.
Latham.
And I apologize again. What was the first name?
Really? Why didn't you just ask me for the whole name?
I was already writing Latham. I don't know. It was just, that's a me
It's
problem.
Carolyn.
Carolyn. Oh, thank you.
That's YN.
Oh, okay. I was gonna ask like Little House on the Prairie, Ma, or like with the Y. So with the Y.
What?
Because Carolyn.
I don't know. No,
Miss
no. When I said what, I didn't want you to explain again. I just needed this to end. Okay.
Fair.
Thank you, ma'am.
Thank you, Your Honor.
Court calls the case, People versus Yuli Walker.
Conrad Seller on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Walker. Mr. Walker, please state your name for the record.
Bobby Walker.
Yes.
So Your Honor, Mr. Walker is here for a pretrial. I would like to address bond. I think procedurally, when he was arraigned on the 16th, you gave him a bond. In between that and today, there was another case that was authorized. He has been, or was sworn to, or he was arraigned on. He was given a personal bond on that case. I believe he has, Exjail has his bond set at 10,000, 10%. My courts had something else, and it said he
My court
posted.
had what?
My court said it was, no, my court said it was bond denied, and it also said that he posted a $2,500 bond. Yes. So.
It said his bond was denied?
Yes, as of July 30th.
So I believe he posted a surety bond and that the agent revoked it.
Got it.
I do know he's also on our felony document.
So, okay, so he posted a surety on this one.
Uh-huh.
The surety, probably because of the other case, I'm guessing, revoked his surety bond on this case.
Okay.
So, well, I'm still not sure why it would be denied, because it should just read what I said it for before, but I'm not gonna worry about it.
The surety bond was revoked.
Their security bond was revoked, but my bond still stands. So I don't know what.
Yeah, my court said bond denied, so.
My court.
I'm gonna go with what.
My court, so.
Your Honor
go with
said.
that?
No, I don't.
Boy, oh boy, if you guys would just get into the system you had, we'd know.
I'd have to agree with
But
you,
we
Your Honor.
can't get into that system, nobody can. In fact, the victims advocates are upset because they can't see anything. And they're the ones always looking for it. I could go on a little tirade about now, but I won't go on it. I'm saving that for later. Okay.
Thank you, Your Honor.
And I'm not
related
related
to
to
you,
anything
Mr. Walker.
between now and then so that I'm really angry.
Oh, boy. What is the new charge? What is the new charge?
I don't know.
It's a possession.
Okay.
Controlled substance under, I believe.
The
under
new
20.
charge?
Yes.
Okay, and when's his next court date on that?
Tomorrow.
Before me?
Yes, sir.
Okay.
And he has a personal bond on that case.
They give him a personal on that case.
According to Exjail.
So, okay. Okay, so does he have a personal on that case? Let's see if we can find out, because hey, I have access to jazz. But I'm not sharing any of that with anybody.
It's a,
Yeah, actually.
it's a court system problem, not you.
So
We're talking about.
can I ask a question? And maybe you can answer this. When he was arraigned on July 6th, who was that? Was that you, Neve?
Sir?
Okay, never mind. So why? That's unusual for me, but I'm not sure. Did he have something else pending that I gave him this bond?
You gave him this bond because when he appeared before your honor at arraignment, he made an admission that he might test positive for.
Yes, that's right.
Yeah. So he was out for 10, so he was arraigned on the 16th. He was in for 10 days. I think he posted his bond on the 26th. He was out for like a day. And then they picked him up on the warrant on the new case. They arraigned him on that case. And then that's when all the bond stuff happened. But I do have information that about a treatment program that I would like to bring to the court's attention if.
Sure, because I haven't been able to stop it going.
So Mr. Walker has been accepted into a dual diagnosis treatment center in sunny California. This is covered by the VA through his insurance through the VA. It's a
You're a veteran.
Yes, ma'am, sir.
It's a dual diagnosis treatment. It's a little bit of specialized treatment, and that's why it's California due to the death of Mr. Walker's son. It's both like grief and substance abuse counseling intertwined.
Got it.
I spoke to Mr. Walker's fiance, who's present in the courtroom, who provided me documentation from Northbound Inpatient that they are going to be flying him out if he's released from custody. So,
okay.
And I can provide a copy.
So, does anybody see any reason that they wouldn't release him to do that?
I have no objection.
All right. So, I would need an order prepared. So I don't have a problem. I'm not gonna have a problem with that at all.
I can, does the court want it stipulated with the people?
I think this is Conrad's case, but yeah.
It is.
Just get a stipulated order.
Okay. Okay,
Following
great.
with the details of his release, and that if he leaves that program, he's got to report back to the Washtenaw County Jail. But
Great.
I think that that's going to be the best thing for him.
I think I can get that over to you, Ms. Schiller, by the next couple of hours. So I'll be in touch.
Okay, that's a much better thing. So what I'll do, I'll make it a PR via the order. So I'll leave it where it is right now. I'll make it a PR in the order so that he's not released prior to that order being in place.
Okay.
Got it?
Okay.
Okay, that makes sense.
Yes.
What branch?
Army.
Army?
Yes, sir.
Did I ask you that before?
No.
No?
I never got to that.
Oh. Army.
Yes, sir.
I don't like them, right?
You like them all?
I like them all. Oh, okay. My dad was in the Navy. I don't know that I like Army as much, but okay. Anyway, sir, and as I tell veterans, I'm joking with you, but as I tell veterans all the time, I want to thank you for your service. All right, because I am very much aware that I only get to do what I get to do because of people like you that were willing to do that. All right. Okay. So we'll get you out to that program and good luck to you in that. All right. Okay. I'll give another date. Why don't I give, I will give September 17th, 2025, since we're at 9 a.m. Since it looks like if we can do that, then that'd be good. The thing that you'll need to check once you're out there is will they allow you to appear via Zoom? But they'll check that with the program because sometimes they don't want you in communication with anybody anytime right away, but we'll work that out sometime. Okay? Good luck to you.
Sign a release of information to the public defender's office. So
Thank you.
Court calls the case People versus Keyshawn Jorgensen.
And is that on behalf of the people?
This is an arraignment hearing for Mr. Jorgensen, case entity.
John Jorgensen.
Hold it, say again so you'll come to my screen.
Keyshawn Jorgensen.
There you go. Okay.
How you doing today, Mr. Sampson?
I'm doing okay. I know somebody's gonna ruin my day. I hope it's not you.
Not at all.
No,
Not at all.
All right. Mr. Jorgensen, you're before the court on a misdemeanor complaint that alleges that on or about October 30th, 2023, at the location of 2109 Glencoe Hills Drive, apartment 9 in Pittsfield Township, Washtenaw County, state of Michigan, that you did commit the offense of reckless use of a firearm. Do you understand the nature of that charge, sir?
Yes, I do.
All right. That's a misdemeanor punishable by up to 90 days in jail, a $500 fine plus court costs, and the court may suspend your hunting privileges pursuant to statute for up to 3 years. You understand that, sir?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, sir.
It's a public defender case.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Jorgensen. We waive formal reading, stand mute to the charges, please.
Defendant every way, formal reading, standing mute. Court will enter a not guilty plea. Pre-trial in this matter will be adjourned to September 17th, 2025, 9 a.m. All right, sir?
Yes, sir. Thank you, guys.
And then what I'll do, I'll set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, no assault, including no insultive behavior or possession of any weapons. There is to be no possession of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, sir.
All right. We're all set. Thank you.
Oh,
Thank you.
Well,
Have a good
hold
day.
on. Hold on. What? What, Perry?
Because, not to bring up any hard feelings, but because I can't check JAS if we have.
What? What'd you say? I didn't hear you.
I can't check JAS to see.
You
if we
can't
have
check GIS.
contact information.
What the hey?
So, Mr. Horgan.
Hold on a second. Can the prosecutor do it for you?
Well, Your Honor, I don't want to ask them to do any more work.
They can't check GIS either.
Yeah. But I would never ask Miss Linda to do work for me because she's so busy.
Really should. So what do you need?
I
will do anything in the world to make this easier for everybody because that's my mission in life.
Well, I appreciate that, Your Honor. I would just ask Mr. Jorgensen, I guess, to
call the public defender's office.
Yeah.
Okay, sir.
It doesn't matter if
you need to call the public defender's office so you need to give them a email address and a phone number they can reach you and make sure that they have your correct address.
Okay.
We're having problems with people messing with our system.
Yes, sir.
So they can't just get that information.
If
You
there's-
need that phone number?
No, sir. I got it. It just popped up at the bottom.
You got
of
it?
the screen. Yes, sir.
Okay, fantastic. All
Thank
right, so please do that right away.
Yes, sir.
All right,
Thank you.
Thank you.
See, that wasn't so hard, Perry. It, of course, gets a lot easier when you can just look it up. Court calls the case, People versus Shannon Keithling.
And on behalf of the people. Arraignment for trial.
Another one. Okay. Come on up. You Miss Keithling?
Yeah.
Yeah, come on up here.
I don't hear very well.
Are you? Okay.
I have my hearing aids in, if you could just speak up a little. Where?
You want me to yell?
No, you don't have.
No,
to
I'll yell at you. Come on. I don't have a problem with that.
I have them in, I just still can't hear 100%.
It's
No,
okay.
You're good. Okay.
Will this help you?
Oh, I can't.
You can't
Oh,
use.
yeah.
Give that a shot. Let's see. Does that help?
No, it's just fine without it. You're
Sure?
good. Yeah,
I just gotta yell at you.
no, you don't.
No, it's okay. I'll do it. Were all those people in the back row with you? Were they?
I have a very supportive oh my gosh, our families.
I know, I saw you
We're
sitting
tight.
back there.
We're all really tight.
Yeah, I could
Yeah.
see that, and I kept thinking, okay, who's the one that did something? Allegedly. I'll tell you, I didn't think it was you. I thought it was that guy on the end over here. He just looked a little sneaky. All right, anyway.
I'm shaky. Look at me.
Are you nervous?
Mm-hmm.
Why?
Because I just have bad anxiety.
Am I
fine.
scaring you?
No, it's not you. I'll be okay.
Really? I want to be scary.
I will be okay.
All right.
Thank you, though.
Okay. All right, ma'am.
Yes.
You are before the court on a misdemeanor complaint that alleges that on or about July 3rd, 2024, at the location of Glencoe Hills Drive near Washtenaw, okay, in Pittsfield Township, Washtenaw County, that you did operate a motor vehicle while intoxicated.
Yes, sir.
All right. Do you understand that charge?
Yes, sir.
All right. There is also a second offense notice on this case, meaning that there's a prior offense that would make this a misdemeanor punishable by a $200 to $1,000 fine plus court costs, 5 days to 1 year in jail. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. So the first question I have for you, ma'am, is, do you wish to be represented by an attorney?
Yes, sir.
All right. The public defender case, not Nick.
We have a special visitor today, Your Honor.
Why? Why is he here?
I asked him to speak with Ms. Kiesling before her arraignment so we could get a little bit more information from her.
Oh, so it's your fault.
Yeah,
Okay.
and he was gracious enough to agree. I added more work on his plate, but
I'm glad I didn't have anything to say to that. Come on up, Nick.
Assistant Public Defender Nicholas Bukovitz on behalf of Ms. Kiesling.
And Your Honor, not, would we be able to briefly approach?
Fine. Come on. What was the alleged VAC in this case?
In this case, Your Honor, was a .168, and it was a 2-car crash. And the prior is from 2023.
Pardon?
The prior is from 2023, Your Honor.
And I was informed that there's actually another one coming up, another drunk driving coming up.
Correct.
Which I did speak to my client about, Your Honor.
Pardon?
I did speak to my client about that, Your Honor.
Okay, where is that one? Where is that alleged to have occurred? Is it gonna come before me or? Because it's not gonna,
It should be coming to Your Honor. It's from Pittsfield.
it's from Pittsfield. Okay. All right. Counsel, you waive formal reading, stand mute.
Yes, I will waive formal reading and stand mute and address bond when appropriate, Your Honor.
Defendant having waived formal reading, standing mute, the court will enter not guilty plea. Yes, that's the bond.
As to bond, Your Honor, I'll be requesting a personal reconnaissance bond. After speaking to my client, she has indicated she has regularly attended AA meetings as it relates to her sobriety, and she has attended, since after these alleged offense dates, she has attended outpatient and inpatient treatment. As noted by Your Honor, she does have a very great support system in the back of the courtroom, including she'll always be residing with either her mother or her sister. Her sister is here today in court, has informed me that she does have very strict rules when my client resides with her, including no drinking, no smoking, ensuring that she has a very safe environment that ensures that she will not have any further issue with any substances. She has been able to provide my office with updated contact information, so we'll be able to remain in contact with her throughout the case. She will comply with any court orders as it relates to any testing requirements or any device such as the sober link or the scram tether. She does not drive anymore, and she does have reliable transportation through her sister for all future court dates, so she will come back. So I'll be requesting a personal reconnaissance bond.
I'll set her bond at a $25,000 personal recognizance bond. I will indicate I'll order standard conditions, including no assaultive behavior, or possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. Was there something that people wanted to say?
Sure, at this time, I would just be requesting a scram tether.
That,
Okay,
given the prior, given this, and given that there's one in the pipe, the court will order that the defendant report over to community corrections for placement on a scram tether. Okay. And pretrial in this will be adjourned to September 3rd, 2025, 9 a.m. All right.
Thank you, Your Honor.
Thank you.
thank you.
You're welcome.
Have a nice day.
I'll do the same. You might want to stop over there on our way out. And we had, certainly there were the issues in terms of what she said over at community corrections. There are all those things, and you have cocaine showing up in her system. And that was on June 4th that we were here, and she admitted to the violations. And I had revoked her bond at that time. Ultimately, she got out. On the 18th, this is June. I adjourned it to July 16th today, or July 16th, and her bond was continued, and she was to continue her testing. And then ultimately from the 18th, it gets from July 16th, it gets adjourned to today. Starting in mid-June, or the end of June, June 30th, well, I'm gonna start mid-June, June 18th, positive for cocaine. June 30th, positive for cocaine. July 8th, positive for cocaine. July 16th, cocaine does not show up. I'm presuming she's supposed to be on the benzos and opiates, but. And if it had started to head that way, we'd be fine, except that the next week, well, 5 days out, she's positive for cocaine again.
She says she's not using cocaine. She says that the tests are incorrect. She's gotten the tests since then, and it was negative. She wants the court to know that.
Where?
At community corrections.
She's done a test since when?
7/31, her test was negative.
Today.
And she said she tested today.
Right, right. But the test before then was not.
I really don't know what's going on with that test.
You're using cocaine. That's what's going on. I mean, I don't. I just don't know who you think you're fooling.
I took 2 more tests. I don't know what's going on. They didn't even give me the test results for today. She got the other one for the 30th. That's the only test that showed up right after I went to court here.
What?
After I came in on the 16th.
When I revoked your bond, that was mid-June. I just read off every test since mid-June. And virtually every test, you're positive for cocaine.
It takes a while for it to come out your system. And I have bad.
Okay, let's assume that's correct, and it's not. But let's assume that that's correct. Then the cold-hearted reality is that when it was supposedly out of your system on July 16th, we should have not seen cocaine again. Yet on July 21st, I have cocaine again.
But that's what I'm saying. In the other night.
I'm not putting up with it. You're gonna have to figure it all.
I have not been doing.
Absolutely, you have just decided that you want to use when you want
What
to
about
use.
today's test and the other tests?
What about the positive test?
I don't know how it got there.
I do want to say on behalf of Ms. Beaver, she is engaged in CCOP at community corrections. Through CCOP, she is attending AA meetings as well. She did provide me with an attendance sheet. She's going multiple times a week. Her last test being twice on the 30th. Is this also a test too?
Yes.
I'm sorry, I misspoke. Her last AA meeting being the August 1st. So she is engaged in treatment and AA. I'd ask the court
Does she
consider.
have a prescription even for the opiates?
Yes, I do.
I believe she did give the prescription for the benzos and the opiates to
That's what I thought, but
community corrections.
it's not necessarily my concern. I mean, it's a cold-hearted reality. 1, 2, 3, 4, 5, 6, 7, 9. The last 9 tests, 7 have been positive for cocaine.
But that's when I first got arrested. And it takes a while to come out your system. I did jail time. I was in jail for 2 weeks.
Oh, I know. I put you.
And it was still in my system.
No, you weren't testing while you were in jail.
When I got out.
I know.
But it
showed up. Why do you think it just showed up?
Because
you used.
I have 2 half of kidneys. I had kidney cancer. It takes a while to come out your system.
So you want to explain how it comes out of your system and then back in your system and then?
I tried to get that test done over. They said it was too late to do it over. I don't understand how one test comes up and the rest is negative.
Because you're using.
Your Honor, I'd ask you to consider keeping Ms. Beaver's bond the same and having her continue to go to CCOP. In the alternative, if she is remanded to the jail, would Your Honor consider releasing her to inpatient?
I would consider release to inpatient treatment. She needs some kind of help because she can't even be truthful with herself. And at this point, bonds revoked, defendant's remanded. We'll see you on September 3rd. I'm done.
Ms. Beavers, I think, would like to request a hearing on the test results and the bond violation.
You can have a hearing on the 3rd. It's my next available day. Call the case of People versus Eduardo Benavides.
All right, so we have this.
Ma'am, who are you?
I drove Miss Beavers here.
Yes, I'm keeping her.
May I ask for how long?
I don't know right
She
now.
have kids and stuff and.
Ma'am, I think you just heard this hearing. I get it. That's why after the first time she did this, I let her out. And she just won't stop.
Well, I'm a living witness for a test saying something that I've never had.
Ma'am, I'm not gonna say, I'm not debating it with you. You can leave now. Thank you.
Yes, sir.
Your name, sir?
Eduardo Benavides.
There's no, whether you have this as arraignment. Was he arraigned on this? I don't see arraignment. No, it's scheduled for arraignment before me today. So, sir, you are before the court on a citation that alleges that on or about July 11, 2025, at the location of Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, that you were in possession of rare paraphernalia, particularly a glass crack pipe. Do you understand what you're charged with?
Yes.
That is a misdemeanor punishable by up to 90 days, $500 fine plus court costs, and that rehabilitative services is deemed necessary. You understand that, sir?
Sure.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes.
All right, this is a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Benavides, we would waive any further reading, ask that a not guilty plea be entered. My client stands mute and ask for an adjourned pretrial date, please.
Defendant having waived formal reading. Standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned September 17th, 2025, 9 a.m. I'll set the defendant's bond at, if I sent you over for a drug test, are you gonna come back clean?
What's that?
If I sent you for a drug test, are you gonna come back clean?
Probably not.
What would be in your system?
Probably weed and probably powder.
At this point, I'll give him a $5,000 personal recognizance bond. I'll give that to him. But then I'm gonna indicate I'm gonna order standard conditions, including no assault or behavior or possession of any weapons. There's also not to be any alcohol, recreational marijuana, or any illegal drug use. I need a CC order. I also want you to report to community corrections. You can report today. I want the first test today, if they can do it today when you leave here. You understand that, sir?
Yes, sir.
Your Honor, I know it's 4 p.m. and Mr. Benavides, he did indicate obviously he would go over there right now. If he does show up to community corrections and for some reason they're unable to actually test him today, can he report tomorrow morning?
Yes.
Okay, thank you, Your Honor.
But that's only if they're unable to do that.
Understood.
All right. Thank you, sir.
All right, so we are here in 25S000112. We have the plaintiff, Dustin Saylor, present. We have the defendant, Michael Nichols, present as well. Mr. Saylor, you can unmute at this time. So for today, this is purely procedural. I'm making sure that everything has been mailed in correctly and served to the court. I do see that you did file proof of service, sir, so I'm just going to confirm that on my end. So proof of service. So you used the sheriff's office to complete service, and I see that that was filed. Okay, sir. So thank you for filing that proof of service. Let me go ahead and look up the small claim in this matter. Mr. Nichols, are you aware that Mr. Saylor is requesting $6,157.56 in reimbursement from you for a
Yes, I know
defective
that.
UTV? Okay. All right. So at this time, Mr. Nichols, we have two options. One is that I enter a default judgment for Mr. Saylor, where you will work with him to repay him that amount, or if you wish to contest it, we can go ahead and set a trial date.
I'd like to contest that.
Okay. So we are going to go ahead and set a trial date. We are a little bit far out because we are a little heavy with small claims trials right now, so I apologize. My next date would be October 8th at 1 p.m. Does that work for everyone?
It works for me, yes.
Okay. October 8th at 1 p.m. I would like to reiterate to everyone, we will be appearing via Zoom like this, but it'll be in courtroom 6, not courtroom 8. 6. Because trial is set for October 8th, that means that exhibits for this trial are due September 26th. That is a Friday. Everyone must bring 2 copies of every exhibit or piece of evidence that they wish to use during trial. That's because the court will retain 1 copy and then the opposing party will get to have a copy as well, so they know what's being presented against them at trial. So please, Friday, September 26th is the exhibit or evidence drop-off at the Cowlitz County District Court Clerk's window. There must be 2 copies of everything. That means starting the 29th of September, you can come in and pick up any exhibits that have been dropped off for you at the clerk's window. That'll give you a week and a half to come get your stuff before trial is on the 8th. Does anyone have any questions?
I have one on the picking up the information before the trial date.
Okay.
Is that what you just said?
Yeah, so
You can
drop
pick it
off
up
exhibits by September 26th. That's a Friday at the latest. Starting Monday, September 29th, you can come to the clerk's window and pick up any of the exhibits that have been dropped off for you. And you can pick them up anytime up until the trial date of October 8th.
Yeah, well, how does the judge get to see the evidence before the trial?
I am the judge and I review the evidence that you
Oh.
drop off.
Oh, I see. Okay. All right. Makes sense.
Okay. All right. Well, then I will see you both back on October 8th at 1 p.m. in courtroom 6 via virtual appearance. Please drop off your exhibits no later than September 26th. If they're dropped off past that, I will not accept any for trial. Okay.
Okay. Thanks, Your Honor.
All right. See you then in October. Thank you for your time.
All right. Bye-bye.
Bye. Let's do Frank Beck. All right, Mr. Beck, if you have video feed, please turn it on. We are here in 25S000110. We have the plaintiff Frank Beck present. Please unmute. *6 or unmute. Mr. Beck, please unmute. Thank you, sir. Do you have video? Do you have video feed?
Yes.
Please turn it on. Thank you. The defendant, Dan's Trans, is not present. That's because there has not been appropriate service or proof of service in this matter. So, sir, in this situation, you would need to amend your small claims form and try to reserve the defendant in this matter.
Well, I'm live, but she's not.
I think she's frozen.
I'm not frozen. I have perfect service on my end, so I apologize if there's...
So he's trying to get him served. It's taking a little longer than normal. He's wanting to know if he can postpone this.
The only way to postpone this is for me to dismiss this lawsuit and for you to refile later. But you, how it'll work is you can come in and amend your small claims, and then you would have 30 days to serve him. If after the 30 days you have not reserved him, we would dismiss it on our end.
Okay.
Okay, we will do that.
Okay, so please come to the district court clerk's window, ask to amend your small claims form, and then you will have 30 additional days to try to serve Dan's Trans and Auto Repair, okay?
Thank you.
All right, thank you for your time. Could you please call in Aricia Sanchez? Thank you. All right, Ms. Sanchez, we are here in 25S000084. We have the plaintiff, Aricia Sanchez, present. We do not have the defendant, Rodman Realty or Don Rodman, present. So I'm going to look over the docket.
How long do they have? Because if someone's not present, then we should be able to move forward after a certain time. And I'm in nursing school.
Ma'am, I will control how this one goes. And so I will tell you the procedure today. I understand that you sound sort of frustrated, but
Because
need
I've
to-
been waiting for approximately 25 minutes. Court was at 11:30. So if we're required to be here at a certain time, it should be starting at a certain time.
Do you think, oh, no, that's not how that works. Do you think you're the only individual that has a case on today?
No, I'm not saying that at all.
Okay,
I'm
well, then
saying
you
my
wait
court was
until
scheduled
you're-
for 11:30. So don't be
Well-
disrespectful.
Okay, you can go back into the waiting room and then I'll call you back after I handle the next matter. Thank you. All right, so before we call her back in, I'm gonna go ahead and actually, did I do that correct? Yeah, I just want to make sure that.
Yeah.
Okay, perfect. Thank you. I'm gonna go ahead and just pull up Miss Aricia's. I just want a second to look after what the docket is because I'm a little confused. There's been a few steps. So I set this trial for August 20th, correct? At 1 p.m. in person. Sanchez at counter. So then the plaintiff asked. And then I set it for 7/16, so we may reschedule the trial dates, correct? Uh-huh. Why is she here today?
The notice was issued for pretrial filings for today.
So it was set for today to set a new date? A new trial date? Correct? Per me, set for small claims pretrial in due course with notice, so trial date may be rescheduled.
So plaintiff Sanchez submitted correspondence, whatever that correspondence was, we decided to set it over.
Well, it was her asking to reset her trial date because it didn't work for her schedule. So we were doing her the benefit to reschedule the trial.
So in this case, the notices that were issued. Well, we don't know.
Were notices issued?
Notices were issued.
So what do you do in this situation when they should be here? But it's a retrial reset.
The trial.
It was canceled. It was canceled.
My guess is that the defendant did the notice.
Do we set it over 1 week because it's her motion to reset a trial date? But that won't give enough notice to the parties. And I mean, already trial would be set way out into October. Or we can just reset trial and send him the new trial date.
I'm just wondering, it's the date, or I guess the address for government would have been supplied by the plaintiff.
But they appeared many times before, so obviously it was served upon the right party. Here, we can call her in. Let's go ahead and call her in. So it looks like the 8/20 trial date was canceled. Okay, sounds great. So 8/20 trial date was canceled in this matter, and then, okay. All right, Ms. Sanchez, let's try this again. So it looks like in this situation, you asked for us to cancel the trial date because there was some kind of a conflict with your schedule.
Yep.
But it looks like the defendants are not here, so I'm not quite sure why they're not here. We can go ahead and set a new trial date, and then we can send them notice of the new trial date. So
Okay, sounds great. Thank you.
the new trial date that we have is October 8th at 3 p.m. Does that work for you?
I have to check the date. Yeah, that should work just fine.
Okay, so October 8th at 3 p.m. is the new trial date. That means that you need to drop off exhibits by September 26th at the latest. And you're asking for an in-person trial, correct?
It doesn't have to be in person now.
Okay, so not anymore. I think that you requested that originally, so, okay. So then we will remove the in-person request. We're gonna go ahead and set it for 3 PM then. So just so you know, it's not gonna be Zoom courtroom 8, it's gonna be Zoom courtroom 6. So please write that down so you're aware of the different courtroom. And then, so trial exhibits dropped off on September 26th. Pickup for exhibits will be on September 29th. And please bring 2 copies of every exhibit that you wish to use at trial, okay?
Okay, thanks.
Okay, thank you. All right, so we need to send notice. I'm sorry, is this whiteout out or am I just losing my mind? I think it's out. Okay, thank you. May I just use that for a sec? So we need to send notice to, and honestly, if they just don't show up, then it's just a default judgment. Send notice. I don't know if there's any way in the notice to put exhibit drop off is due by the 26th. Like you failed to appear. These are the requirements from today's hearing. Just don't know if that's,
All right, this is case number 08S01572OM, People of the City of Southfield, versus Dante Williams.
Good afternoon, Your Honor. I'm not sure if there's someone there on behalf of the people, but Jade Mathis on behalf of Project Clean Slate on behalf of Mr. Williams, who's here on Zoom, with a white shirt. Mr. Williams, can you please unmute yourself and state your first and last name for the court record?
Yes, ma'am. Dante Williams.
Thank you.
All right, Mr. Williams, you are here today for a motion hearing. This is a motion to set aside a conviction for retail fraud, 3rd degree. And let's see what's in my file. Thank you, Mr. Shockley. All right, so my file has a criminal history record from the Michigan State Police. We'll go through that, see where we are. All right, so let's see. It shows a 2008 matter out of this court, which is the retail fraud. So that's the subject matter of this petition. It shows 2011 out of 36 district court, another retail fraud, 3rd degree. 2015, 39th district court, another matter. It was dismissed, but then there's an assault and battery as a count 2. So it looks like the retail fraud 2nd degree was dismissed. The A and B he pled guilty to. Uh, 2016. Driving while license suspended out of the 52-1 district court. (2019) 4th Circuit Court. Fleeing and looting the police. 4th degree. Another 2019 out of the 4th Circuit Court. An attempt felony of assault of a prison employee or employee of another place of confinement. (2009) 40th District Court, St. Clair Shores. There's one matter set aside there, but then, let's see. Then there's a 2012 out of that same court, 40th District Court. Another retail fraud. Third. And looks like this other matter had a nollie price. Okay. So moving down to another 2010 out of the Third Circuit Court. This is a unlawful driving away, but it looks like that got deferred, so we won't count that. And the other count was deferred, and the last count was deferred. So then we have a 2012 out of this court. It was set aside automatically. Then there's a 2013 matter out of the 17th District Court. It was set aside automatically. And then there was another count that there was a sentence delay. And it doesn't tell me what happened, but it says he was convicted of it. So that was 2013 17th District Court interfering with a police investigation. In 2016 out of the 19th District Court, that was something nollie priced. And then another thing set aside. But then he also had another assault and battery out of that same court from 2016, 19th District. So by the looks of things, including this case, there are 1, 2, 3, 4, 5, 6, 7 misdemeanors. And looks like there's 2 felonies, being the fleeing and eluding, being 1, the attempt felonious assault being 2, and then there's a third one, the assault upon a prison employee. So I guess 3 felonies and 7 misdemeanors. I have a May 29th, 2025 letter from the Michael Ajami, the Assistant Attorney General, with the assistance with Convictions and Expungement Division of the Attorney General's Office, saying that he's reviewed the information here, criminal history in the application, and that if I hold a hearing and agree that Mr. Williams meets the eligibility requirements, that I might enter this order granting the application after I determine what is post-conviction circumstance, behavior, warrant, setting aside the conviction and are consistent with the public welfare to grant it. So let's hear from counsel and then the defendant as to what his post-conviction circumstances have been and whether it's in the public welfare to grant this application.
Where you're before we hear from Mr. Williams, I know you read his lengthy past, and we did talk about that and how that is probably going to be concerning to Your Honor or raise some concerns. But I will say he has been, particularly in the last few years, he's been doing very well. He is self-employed. He does have an established LLC. He owns a boutique for the last 3 years. He's 3 years. He's also obtained his adjuster's license. In that time, he has some college completed. He is a new dad. He has a newborn. It's about a little over a week old now. He has said that he's seeking this expungement today because one, he's young. He's 34 years old. A lot of these, particularly this 09 case happened when he was much younger. And he did explain to me that he had a pretty rough childhood growing up. He was in and out of the foster system for the majority of his life, grew up in an impoverished area. Also, a lot of the crimes he committed on here, mainly theft and some of the assaults were for survival, as he has noted to me, and to merely survive every day. And he's saying that with his adjuster's license, he would like to start working again, and he's unable to do that with his record. So he would like to be able to pass the background check and to start contributing to his family and society in a greater way outside of his boutique that he now has that he's been running for a few years.
Yes, we got a very lengthy record. Very. Some of the things were actually automatically set aside, and he still has 10 matters that he's got to get off before anybody's going to give him any type of license like he's looking for. What's he trying to be an adjuster for?
Mr. Williams, if you...
Is it insurance?
Yes, how are you doing, Judge? Yes, it's an insurance adjuster for like catastrophic disasters and stuff. Like basically we'll travel and do like estimates and basically for claims. Yeah, these cases are no less than 7 years old for every case that's on my record, Your Honor. And I'm just trying to, just pretty much just, escape the past. And I know what I did. I accept what I did was wrong. But like my attorney said, it was for survival. And it's no excuse. But, when you're not as fortunate as everybody else, it's hard to get by. So unfortunately, I had to go out and steal sometimes for me and my siblings to basically like get stuff to eat, clothes. It was nothing like I was just breaking in houses or like, you know what I'm saying? Like the rest of my community were doing or carjacking or anything like, so these are like, well, I wouldn't say minor, but they're retail fraud and, I'm not proud of it. I am the shame. There's and really the charges from 2019 was the most recent, and that was 7 years ago. And I'm just trying to just get this, off my back. It's really hindering me. Like I got my license, and now that I went to pursue the job, they're saying like, oh well, you have to get, the charges set aside for me to actually work. And granted, I do own a business, but I also want to work. Like, that's just what I want to do. I haven't stolen anything in over 10 years. Now that I'm grown, I just have a different outlook on life. I just had my baby Lux. He was born July 28th of this year. And, I've been fixing up my credit, just trying to go down a better path, Your Honor.
Well, Mr. Williams, and this is one of the things that I try to tell young people, because you're still young, but and learning, but a lot younger at the time, is that everything you do follows you. And look at where you are now. You're a changed guy, you're a new dad. You want to earn something the right way. You're trying to start your businesses. You want to get another job to support the family and start that side of a new career. And all of these different convictions are holding you back. And, some of the things were set aside and they weren't all for survival. I mean, you got some of them for fighting and some of them driving away somebody's car, A lot of them was driver license problems, and that's not per se survival. Maybe the retail frauds might have been interfering with a police investigation. I don't know what that was about. But you just got a lot of random things, fleeing and eluding the police. And a couple of other, assaultive things.
And
So-
I'm sorry.
Yeah, go ahead.
The assaulting was two of the most of the assault charge that I have, as you can see, like it's come from retail fraud as well, and that's for me like resisting. They just slapped that charge on me, like just because I was resisting from whoever was at the store at the time. It wasn't just because I hit them or anything. It just like it's that was unfair to me.
Well,
And
it's still a crime.
yeah,
See, when you do a crime, you can't say another crime that you do in the course of the crime that you are doing is unfair.
mm-hmm.
It's just another crime, and that often is the case. So the best thing you can do is what you're trying to do now is get yourself out of the crime business in any kind of way, shape, or form.
Yes.
And it sounds like you're making an effort. I mean, that's what I can say. It's a lot that you've still got to get off your record, but I think over time you should probably be able to get most of it off.
Yes.
And it's a learning experience, and I like the fact that you understand that you gotta be a role model for this new baby.
I know.
And you can do that, and you don't have to hide the fact that you started off wrong. But you got to show them how you finished. How you finish is really what matters. And if you finish and you're hopefully a God-fearing man, and you've changed your ways, and you start the business, and you're obviously doing well enough in your own businesses that you're able to maintain for yourself. And are you married to the baby's mother?
No, we're actually we were friends, and we planned this baby like for the past 2 years.
Why would you plan it and not want to be a real family?
Because it's just that's not what we decided to do. We're still a family, but we're just not together.
Well, that to me makes no sense. How do you raise a child? You're not together. Was she going on to marry somebody else and you just got a baby? Okay, listen, Mr. Williams, you got some more growing to do to understand what a real family is and why we as African Americans need to establish these family units. We don't need to be having these babies out here like this. A family unit matters. A dad right there in the home with a real mother that's a role model for all the children that you're raising. We don't have that like others did. And we have the ability to have it. We just stopped doing it. And I'm gonna tell you, we didn't have a bunch of nonsense when we had that. So people of my age group, we had that.
Yes.
And guess what? 99% of us turned out pretty darn good.
Yes.
Because we had that in the household. You need to think about that. I can't force you to get married, but I can tell you this. You need to report to courtroom number 1 at 26,000 Evergreen with a marriage license, and you guys need to get it together and make a plan, and I'll marry you. I sure will. That's what you need to do. Make a plan for that future. Decide how you're going to raise that child together and make it. If you're friends, that's even better than having a real close, romantic relationship. Obviously, you had some kind of romantic relationship, because you wouldn't have got a baby. But you got one, and you're friends. And friendship has got to be the basis of a great relationship. Because you understand each other. You know each other. You know how to disagree without making it a major scene. You can plan together. This is good. So you all need to consider that and make a family, because this baby is like your future. And quite frankly, your baby is the future of the rest of this community too. It's not just for you two. It's the future of the culture. And so many things that we see nowadays is so negative with young people. We need young
Yes.
parents to pull it together and start to raise the kind of people that we turned out to be so that we can stop this negative cycle of criminality and no families and just babies everywhere and fathers not paying and mothers over here with another guy with different fathers to the kid. That none of that's great.
Yes.
So you know, I'm not gonna belabor the point because I think you need to think about it. And as a growing man of 30 some years old now, you can see the future of where this is headed, not just for you, but just for the whole culture of our society. And it's just gone wrong. And if one person can make a difference and make that family unit, others may very well see it and take that plunge too. And that's all I'm asking you to consider. And I'm available most days if you want to have a phone call with my assistant and you decide you want to have a wedding. But that's a separate issue.
Well, Your Honor, can I? Well, she likes the same sex. So when she asked me, you know, would I be able to just have a baby for her? Then I agreed. You know, we are a unit, but we're just not together, if that makes sense. So
She asked for a baby from you so she could raise it with another relationship, basically. A same-sex relationship.
Because, well, we're all a unit. So it's like, you know, she did want a dad involved. You know, she didn't want to have like two moms per se. So, you know, I went ahead and I took that vow. Like right now, I haven't missed an appointment, Your Honor, for my baby, you know. And I plan on, you know, being. You're an active father. Yeah, I'm an active father. So we're literally
Well, man,
across
who
the
is
street.
that? Who is that telling
That's
you
the
what
baby
you are?
mom. That's the girlfriend. Would you like to see her?
Sure.
Okay.
Hey, how are you?
Good. You guys got a lot of work to do with this baby. I'm telling
Yeah,
you.
we're raising him in a family household, so he didn't have it from a relationship because he is a very active father. He is a very amazing father. So, you know, he's being raised.
He's only been a father for 2 weeks.
For a village. Well, no, actually 9 months because he's been here the whole pregnancy. So 9 months he's been at every prenatal appointment. So we're raising this baby in a village.
All right. Well, that's good.
Yes. I just didn't want you to think like, you know, we just had a baby, we're not together, and we just, you know, that's not what it is. We have a great relationship. Like our communication is top tier. Like, you know, we're raising a baby on love. We have morals and values that we abide by, that we expect the baby to as well. A lot of stuff have changed, Your Honor. So I know my record is lengthy, but like I said, I'm just trying to bury it. I know, you know, just as much as I can.
All right. Well, that's fair. Mr. Rivers has stepped out, so I'm assuming here he is. Can somebody go get Mr. Rivers and see if he wants to weigh in on this application? You want to weigh in on this application? We've heard from the Attorney General. We've heard from the defendant, the counsel, and the defendant's somewhat significant other even. We heard from her. So what do you want to say?
I'll just say I have no objection to this application, Your Honor.
Okay.
Can I have some water?
I'm sorry.
Can I have a cup of water?
All right, Mr. Williams, get yourself together because I'm about to rule on this.
I will. Thank you so much.
All right, so I'm going to make the following factual findings with respect to your application. I read your criminal history into the record, and yeah, it's kind of lengthy. But I can say this, that it appears to be there's nothing within the statutory time frame that's required under this law in order to preclude this convictions from being set aside. And so you haven't picked up anything within the time frame. But you did have at least 7 misdemeanors and 3 felonies. I don't see where you have been convicted of any more than 3 felonies. I don't think you've had any assaultive convictions set aside yet. Yeah, because they're still here. Also, there are no charges currently pending against you. There's been nothing, as I said, within the applicable statutory time frame. This is not a felony involved at all that you're asking to have set aside. And this is not a first offense, drunk driving. The time frame for this conviction has passed under the statute. An opportunity was given to Attorney General and the city attorney prosecuting official to contest this application, and neither has done so. As far as circumstances and behavior of you and whether or not it's within the public welfare to set aside the conviction, I do find that it is consistent with the public welfare because, quite frankly, you've turned this around. Got a lot of things going on, but you seemingly have gotten yourself together. I mean, you want to be an insurance adjuster for catastrophic occurrences. This is holding you back probably from getting the full license for that. You got your own business. You've been a boutique owner for 3 years. You now got a new son that you're raising in some type of communal environment with the mother and the partner. So that's a good thing. She says you're a very good father in that regard. You said that all of this happened when you were young and you just weren't aware of how this could have really affected your future. Your lawyer told us that you had a rough childhood, you were in and out of foster care, lived in an impoverished area, and the streets kind of got to you for a little bit. And most of the things that you did, you say, were trying to survive, although some weren't, but they were as a result of you trying to flee or fight to get away from the theft things that you were committing at the time. But you've turned all that around. And I think that's what this law is for, is to not hold these things against folks if they've really done the hard work to turn themselves around. And I think to get a better job, to be able to be a better provider for yourself, for your son, is really an awesome goal. And I think that this would enable you to do that. So it's going to be my honor to be able to sign off on this application to set aside this conviction. And this is a conviction for a retail fraud, 3rd degree. And as I've said many times before, we like to keep a little tact and decorum in the courtroom, but we also want to applaud people when they've done something good. So I'm going to ask everybody here in the audience to give him a round of applause for. Okay.
Thank you.
So that's your inspiration to keep your faith. Know that you can move forward and get the rest of these set aside. Make your life plan for your job so that you can accomplish what you want and take care of that baby. And I'm still not convinced that we can't get y'all to get married, but we'll see.
Oh my
Okay.
God. Thank you so much. I'm
All right.
very
Good luck
appreciative.
to you. Okay. And
Thank
I'm going to send the order out to Miss Mathis' office. But if you need another copy, you can certainly come down here and get the copy at any time. Okay.
Yes, ma'am. Yes, Your Honor.
All right. Good luck to you.
Thank you, Your
Thank
Honor.
you.
Congratulations, Mr. Williams.
Thank you.
You're welcome. You all have a good day.
Okay. There we go.